Hello, my name is Christie Arkovich, and I'm a student loan attorney in Tampa, Florida. And one of the things I'd like to talk about today is the Borrower Defense to Repayment program. Now, this program is something that's been around for a few years, but it's gone through a lot of changes. What it is for those borrowers who went to schools like ITT, IADT, Everest, Corinthian, any of those for-profit or even non-for-profit schools that engaged in some kind of fraud. And typically you're looking at things like ineligibility to transfer credits. Maybe they're not accredited. Maybe they improperly gave the cost of education. A lot of these schools, they talk about financial aid. But when you look at the financial aid, there's certain parts that are grants that you don't have to repay and scholarships, and then there's loans. And so there's a disconnect between what the student is told that they have to repay and what that payment's going to be and what it actually turns out to be. And so that hidden cost of attendance, cost of education, that's something that can be fraud if the school has not properly told the client, here's what to expect upon graduation. And expectations upon graduation could extend to salary considerations, job placement rates, things like that. Any statement that the school, through its admissions office or financial aid office, has made that is fraudulent, false from the get-go, then that's something that the Borrower Defense to Repayment Plan was designed to correct. And so it's gone through a lot of iterations. Initially, it was just a couple of lines. Congress passed something that said, hey, if you encounter fraud, that you have a defense to repayment of a federal student loan. And that's all it said. It was very, very simple, a couple lines. And so when the Department of Ed ended up getting, 100,000 applications all at once, when Corinthian and when Everest failed and filed bankruptcy, then it had to create this long program. And so it did so, about 700 some pages or so. I read it on my patio one day. It was kind of a nightmare. It was like reading the bankruptcy code. Anyway, we initially started filing those applications on behalf of borrowers, student loan clients, and mixed results. Initially, we were getting approvals. And then what happened was the Trump administration and Secretary DeVos took over. And unfortunately, they put a hold or halt on that program. Eventually, when they did start ruling on those again, most were denied. A few got 10% approvals. Well, 10%, that's not much. That's pretty much a denial, right? If you owe 50 grand or 200,000, taking 10% off is not really going to help much. And so our clients were disappointed at that. Well, turns out that President Biden has just, and through Congress, has just put forth an additional $1 billion to provide additional relief for those 72,000 borrowers that have received partial relief, partial forgiveness under the Borrower Defense Forgiveness Program. So we've had a few of our clients reach out to us and say, hey, do I qualify for this? So what we anticipate is over the next few weeks that the Department of Ed is going to send out notifications to borrowers telling them, hey, you've gotten partial approval in the past under this Borrower Defense to Repayment, BDTR, and we now have additional funds. And I don't know how the letter is going to be worded or what it's going to say exactly, but we could have some folks that get 100% approvals. In fact, I think that we will see many, many of those. And so definitely keep an eye on your mail. If you already have a claim, if you've had partial approval, they're likely to award additional funds and write off additional monies. If you have not filed a claim, or if you have a pending claim, then by all means keep waiting for pending. For new, file a new one. There is a statute of limitations that's supposed to apply. I was reading it's 3 years here in Florida. We argue it's longer because we have a few things that we can use called the discovery rule, the equitable tolling rule, the fraudulent concealment rule. There's certain rules, evidence rules that allow us to go back further, even though fraud generally has to be raised within 3 to 4 years. And so there may or may not be a statute of limitations going forward, is what President Biden was indicating. They are rewriting the rules. And so that anyone has a pending claim or who has a claim that they would like to consider filing, you need to do so. You need to get in order. You need to get in line with everyone for those, because if they streamline this process and they eliminate the statute of limitations, that won't be a consideration anymore. And you can go back to prior to 2006, prior to 2000. I mean, we have clients that have student loans from the 1990s. The majority of the biggest problems are in the 2000s. generally 2004 to 5 through 2009 or 10 is usually the majority of where we see these for-profit schools engaging in fraudulent misrepresentations. But there is hope for the borrower defense program, and keep tuned in for the changes that we expect to come. And for those who have already received partial approvals, keep an eye on your mail, because more than likely they're going to come back with a far bigger sum with this additional money that they've just went ahead and applied to this program. So thank you very much for listening. Again, my name is Christie Arkovich, and I'm a student loan attorney in Tampa, Florida. And please check out some of our other videos on some other things that the Biden administration has been doing.